This is a common question we'll get with a lot of restaurant industry clients. It's a common situation everybody faces, both in the restaurant industry and in other industries, where a customer either forgets to pay something or doesn't pay the entirety of what they ordered, disputes a charge on a contract, whatever the case may be. In the restaurant industry, it's particularly of concern because in those instances where we're rushing around and something doesn't end up on the bill, you don't want to alienate your customer. You want them to come back to the establishment the next time. And sometimes there's a fear of contacting them, even to ask if we could go ahead and charge their credit card for something that was innocently forgotten when they actually visited our establishment. And so employers look to another solution. Sometimes that involves the employee. In California, employers are not permitted to engage in self-help to retrieve that money, and they're not going to be permitted to simply deduct that from an employee's wages. The situation is that the labor code and California statutory scheme is very protective over an employee's wages. And so in this instance, where we have a situation where they innocently forgot to put something on the bill, we're not going to be able to deduct that from the person's wages. If we can somehow prove the employee intentionally is attempting to damage the employer or harm the employer, the answer might be different, but that employer would have to proceed with extreme caution in determining whether there was intent involved for that harm. Most of the time, the advice is simply going to be to, unfortunately, eat that cost. That's how the Labor Commissioner will go ahead and view it. They're going to view it as something that is a cost of doing business for the employer and therefore should be borne by the employer and not the employee.